probate assets with some fundamentals. Every once in a while, I will get a brain freeze and I'll have trouble remembering some basic elements of math. Why does 1 + 1 = 2? Well, it does. But there are some larger elements that there is a mathematical theory behind it. Well, likewise, there are some fundamental things that people take for granted, and I suspect many people don't even know about how a deceased person's assets pass from the decedent to the people who end up with those assets. I'm going to jump around in the materials that I presented. So right now I'm on page 4 of the outline for those who have that and want to follow along. And as I'm looking around here, by the way, I have a long monitor and you're all up here in the very top right under my camera. So I'll try to look up as much as possible when I'm speaking, but I'm also looking down at my materials below the camera. So the first point, statutory point, where a deceased person's assets pass from the decedent to someone else appears in Indiana Code Section 29-1-7-23. There's been a lot of confusion over that in recent years, which is why there's been so much legislation on the topic over the last couple. Subsection A of 29-1-7-23 has been the long-standing rule that essentially says that a deceased person's assets pass automatically to the distributees under the decedent's will or through the intestate transfer statutes. Now, it's not, it doesn't specify that quite so, or the original version didn't specify it so clearly, but that's where the original decision tree issue happens, where it's forked and you go either probate, through intestate distribution under somebody's will, or you go by intestate transfer. Subject, however, to the power of a personal representative appointed by the court to divest title under a few provisions of the code. After we get past that point, then we have the intestate transfer statute, which is 29-1-1, Indiana Code Section 29-1-1, and that's the intestate distribution or intestate transfer system that provides for who gets an intestate decedent's assets after the decedent's death. It provides for distribution to a spouse if there is a spouse, and to descendants if there are descendants, and to all the other people more distantly related if the more closely related people are not there. After we get beyond that, then we get into the limitations of transfer. So the power of a personal representative to divest title, what we're talking about there then is if you open an estate, the common understanding and the proper function for a personal representative is to gather assets, to address any claims of creditors, basically to pay the decedent's bills, and then to distribute the assets either according to the decedent's will or under the intestate distribution system if there is no will. The principal limitation on the personal representative's power appears in Indiana Code Section 29-1-7-15.1, Subsection B. Now, 15.1 is a busy statute, and it got busier over the last couple of years as we added a lot of details to it. That's also the statute that deals with the deadlines for probating a deceased person's will. The very first subsection, Subsection A, is part of the limitation on when you can probate a will and when you've missed the boat. The Subsection B is where the limitations appear on the power of the personal representative to sell a deceased person's real estate. And the general rule is that if the long-standing rule has been, until a couple years ago, that if the clerk of the court did not, if there are no letters taken out, the statutory term was letters taken out within 5 months of the deceased person's death, then the personal representative could not sell the real estate. There was a fair amount of litigation over this. There was one case I was involved in that went to the Court of Appeals, and we petitioned for, well, the appellant petitioned for transfer to the Supreme Court. The Supreme Court denied certification. So, I'm sorry, denied transfer, wrong Supreme Court, over that power. And we had some legislation defining what rules govern that. But we had a lot of conflict with the Attorney General's office, who was representing the Family and Social Services Administration in its claims to recover reimbursement for benefits paid to Medicaid benefits paid for nursing home residents. As we litigated and then eventually collaborated, gathering a group of people from the Department of Revenue, the State Bar Association, the Attorney General's office, and representatives of Family Social Services Administration, we compromised to establish the current version of 2917-15.1b, and added to it subsections C, D, E, and F. And so now the process is that if you, someone has to file a petition to administer a deceased person's estate within 5 months after the deceased person dies. So if you check the court calendar and there has been no petition filed to administer to the decedent's estate, that is for appointment of a personal representative or testate or intestate estate, if it hasn't been filed within 5 months, stop. You're done. The personal representative doesn't have authority. If, however, it has been filed, then I haven't seen this so much, but I guess if you're pinching the deadlines, you could get there. The Attorney General's office complained that there were cases where clerks were not issuing the letters quickly. And so we developed a compromise initially in the first version in 2018 that if the clerk would issue the letters within 7 months after death, so you file within 5 and the clerk issues letters within 7, then the personal representative could still sell the real estate. Well, then last year there were still some problems with that as far as the Attorney General's office was concerned. So we broke it down into a lot more steps. So now if the personal representative if the petition is filed within 5 months of death, then if the clerk doesn't issue the letters within 30 days, the petitioner should issue a notice of filing of the petition, particularly to known creditors. And then that starts a clock. So if the person who is petitioning delivers that notice under the statute, then the creditors must file a claim. Now, this is backwards from normal understanding of estates. Normally, you don't file a claim until the clerk has already appointed a personal representative and issued the letters. This is a new exception to that rule starting a year ago, or last July, that the creditor, the claimant, must file their claim in the estate within 30 days after receiving that notice from the petitioner. But in any case, they have to file the claim within 75 days after the petition was filed. And of course, the petition is filed within 5 months. So you stack 75 days on top of 5 months, and that gets you just a little beyond 7 months. So in that case, then, if the clerk drags their feet for whatever reason and doesn't issue the letters within 7 months, the creditor can put their foot in the door and protect their claim, so that when the estate is finally officially opened and the letters are issued, the creditor can still pursue and demand that the personal representative sell the real estate to satisfy the claim. So those are the steps. They appear in Indiana Code 291715.1. And then I'm continuing, I'm still on page 4. I jumped ahead for the discussion just now, and I won't take you to the language there right away, but I'll point it out when we get there. Confusion existed over the last several years about 2 statutes in Chapter 8 of the Probate Code. The first one, which didn't really cause so much confusion, but it was a twin sister of the one that did, is 29181. So Indiana Code section 29181. That's the provision that allows for the transfer of assets using what is called a small estate affidavit if a decedent's assets are worth less than $50,000. Now 29181 only applies to personal property, so motor vehicles, bank assets, basically anything other than land. Now the twin sister of 29181 is 29183. And in the materials, the discussion of that appears at the top of page 5. Originally, that was a provision that was designed to give a personal representative or perhaps a guardian in a guardianship where the incapacitated person or minor had died, a way to cut bait, simplify the administration process, and wind it all down rapidly without having to open a separate estate or to administer in complex procedures for low value assets. And it too had has a $50,000 limit. At some point, I believe in 1984, there was an amendment, and a subsection B was added to 29183 that talked about real estate. And from that point on, I think that was the ground zero for this understanding that a lot of lawyers had, that a small estate affidavit with a $50,000 limit applied to land. Now 291723 never changed. It has always had the ruling over that, but somehow people, and I understand how they did, they connected 29183B to that. And the problem is, many of us have, Jeff Dible and I have talked lots of times, and Jeff Kolb, about how we have transferred millions of dollars worth of real estate sometimes. Down here we'll have 3 siblings that will co-own some property. One will have died 20, 30 years ago, and they didn't bother to do anything because that one didn't have any kids. And then at some point we have a transaction that comes up and we have to clear the title. And so we would put affidavit language indicating how the title devolved, or that's the old term, now I have to say passed, under 291723. And we'd pass that, millions of dollars worth of real estate, no problem. Didn't worry about the $50,000. But as the thing kept coming up and coming up, frankly, I got frustrated with it. So I proposed clarifying the language in section 23 with safe harbor language for affidavits. So that's in there now. The version that we put in last year created some conflicts or some confusion about timelines. So there's a new version that takes effect on July 1st that has a straightforward rule that doesn't have really deadlines on it so much. And then there is a more specific rule if somebody, so you can get prima facie evidence that title has passed. If you want to nail it, you can put in the time deadlines that are established in 291715.1 that are specified in section 23. And if you nail that more than 5 months have passed, more than 7 months have passed, there've been no estate, there've been no letters issued, then you have prima facie evidence that the personal representative can't force the real estate for sale. So I hope that after July 1st, the process of passing title to real estate, when that's the only asset, will be much simpler. Now, if you have any personal property of value and the total value of the land and the personal property exceeds 50 grand, then you're stuck with a dilemma. Do I want to open a full-blown estate just for the personal property? Because you can't get under the $50,000 under 29183 if you also have land of substantial value. So you have to decide, are you going to abandon the personal property because it's too much trouble, or are you going to open an estate and do both? And if you open the estate, then you're administering the real estate and the personal property together. So there you have that. I want to move a little faster here because my time is waning. This is a lot of material to cover in a short time, and I had no illusions that I could get it done perfectly. I want to talk a little bit about the process for creditors' claims. So a creditor can file a claim in a probate estate under 29.114.1. I'm sorry, 29.114.1. And they have to file the claim within the deadlines specified there. And then essentially a claim is a form of complaint, and the trial rules govern the litigation of that claim if it's a contested claim. There are deadlines for administering that claim, principally in Section 7, Section 10. A lot of people don't tend to those deadlines. Estates are notoriously lengthy in time and proceedings. But that created an issue at some point for claims against non-probate transferees. So in 2002, and I believe Brother Kolb was deeply involved in setting up the statute for claims against non-probate transferees in 2002. And the idea under that statute, which the chapter for claims against non-probate transferees is 32. Let's see, let me scroll down here to get my eyes on it. 32.17.13. That chapter deals with the creditor's rights to claim against assets in a revocable trust, joint bank account. Now we have transfer on death deeds, so the process for claiming against those. And the two principal statutes within that chapter are sections 7 and 8. So 32.17.13.7 and 32.17.13.8 are the workhorses for how creditors make claims against non-probate assets. The definition of non-probate assets is up at the top of the chapter, and excluded from those are things, life insurance policies, annuities, and retirement plans, and largely a lot of that reason is some of that stuff is involved in ERISA, and also excluded would be the transfer of the shift in value in life estate to remainder interest, and also tenancy by the entireties, because of course you can't make claims against tenants by the entireties property. So the process is that you file, the creditor has to have a timely filed probate claim in the probate estate, because the probate court is where the legitimacy of the claim is adjudicated. And then the creditor at some point must file a written demand on the personal representative. That's under Section 7. So 32.17.13.7. The creditor must file a written demand on the personal representative to file a separate lawsuit. So somebody has to file a separate lawsuit, different cause number, against the trustee and trust beneficiaries or transfer on death beneficiaries. And so if the in order to file a timely filed claim, then they have to satisfy the claims statutes under Chapter 14 of the Probate Code, 29.114. Except government claimants that don't generally have deadlines. So, and that was the big problem. That was the reason for litigation and eventually collaboration on the statutes, was to establish that the creditor had to file a claim within 5 months. So now the rule in Section 7 is you have to file the claim in 5 months, and then you have to file a written demand on the personal representative within 7 months of the decedent's death. And if the claim is litigated, or if the personal representative delays in allowing or disallowing the claim, then under Section 7, the claimant must file a motion to set the claim in probate court for trial on the trial docket within 15 days of the personal representative's deadline. And there's a cross-reference in Section 7 to that statute for the deadline. So if the creditor files the claim in the probate estate within 5 months after the decedent's death and files a written demand in the court and delivers it to the personal representative within 7 months after the decedent's death, then they can preserve their claim, provided, however, that they also have to keep the fuel on the fire in the probate court to adjudicate the claim and make sure that it is allowed or disallowed in a timely fashion. If they do all that, then the creditors can file a separate lawsuit against the non-probate transferees. Last year, we went back and added some old language that we had taken out in 2018 because of some due process issues, but those provisions expired at the end of last year. So with a few exceptions, I have about 30 seconds left. If you're dealing with a Medicaid state recovery claim by the state is bound by these deadlines in 32-17-13 if the non-probate transfer instrument has been disclosed to the state, and I believe it really should be done before death. If the state is notified about the non-probate arrangement, then they are on the hook. Otherwise, the non-probate arrangement doesn't bind them. And I see I've just hit 0, so I will yield the time over to my brother Jeffs.
Okay, welcome from sunny southern Indiana. I'm Jeff Kolb, and talking about a brand new tool in your estate planning toolbox, the Indiana Legacy Trust, effective July 1, 2019. So what is it? It is a self-settled spendthrift trust that will protect certain qualified dispositions from the claims of creditors, including the creditors of the settlor. Legacy Trust is the name given to it. That stemmed from the fact that the original draft allowed the trust to do two things: protect the assets from claims of creditors, and to also create a dynasty trust, which would not be subject to the rule against perpetuities. Indiana has a position on rule against perpetuities. It apparently came down with Moses from the mountain on a tablet, and we've tried many times to change it and haven't been successful yet. We will try again in 2021. We will change the 90 years to 360 years if we're successful. But for right now, the sole function from the estate planning standpoint is the spendthrift provision. Now, asset protection is not a new thing in Indiana. It is not, as one opponent claimed in the Senate Judiciary Committee, to be satanic. You find asset protection in all sorts of things, be it life insurance, be it in tenancy by the entireties, homesteads, compensation proceeds. It's throughout the law. However, in the connection with trust, you have to go back quite a way. And of course, you've got the Roman fide commissum, which put strings on gifts in Roman wills. The English picked it up and their common law expanded it to inter vivos trusts. And at the same time, there's always been the concern, are these going to somehow negatively impact creditors, and so protection from creditors. What we really find, though, is the Spendthrift Trust, which is a protection from creditors, especially third-party Spendthrift Trust. It's an American creation, American common law. And Thomas Jefferson even created a trust for his daughter because she was married to a guy who kind of had a problem with creditors. So that's where the spendthrift comes from. But until July 1st of 2019, Indiana statute trust code said a settlor cannot create a spendthrift trust which protects him from claims of his own creditors. That got changed, the exception being this legacy trust. The whole concept of an asset protection trust started in 1987. A Colorado lawyer named Barry Engel goes to the Cook Islands and he convinces them, hey, I got a deal. You guys can have these wonderful American trusts that are not subject to claims of creditors. All you got to do is change your treaty law. And they did. And then Cayman Islands, Belize, Nevis, Channel Islands, Isle of Man, suddenly it was everywhere. And it didn't take long for people to realize that over $1 trillion in American assets had gone to overseas foreign asset protection trusts. So a nice estate planner in New York had a brother who's a trust officer in Alaska, and they created the very first domestic asset protection trust, which is the Alaskan Trust. Delaware, not going to be Delaware. 90 days later, Delaware passed the same. Indiana's about the 18th state to do it. A little controversy whether Missouri has one or not, and we're the 19th. Now, by important background, in 2010, at the same time all this is going on, courts are attacking Spendthrift Trust, the original third-party Spendthrift Trust. They don't like it when the creditors are women who need money from alimony or child support, and so they began attacking these trusts on discretionary trust basis and alter ego theories. South Dakota, which actively markets its domestic asset protection trust, had statutes that basically tried to say to the courts, these are not arguments you can use to attack these spendthrift trusts, and Indiana adopted those statutes in 2010, the alter ego statute and the discretionary support statute, and I'll talk as fast as I can. Hopefully we'll get to it. Now, very key to these trusts are the formalities. I would never want to have to argue substantial compliance. I would want to make sure that if I create one of these, it's going to meet the requirements. And so it has to be in writing. It has to specifically say it's a legacy trust under this IC 30-4-8. The trust itself has to appoint a qualified trustee who's either an individual resident of Indiana or a corporation or entity that is recognized under the Office of the Comptroller of Currency or the Federal Reserve System. It has to specifically say Indiana law governs. You don't want to change it to other states because then it won't be a legacy trust. It has to specifically say the legacy trust is irrevocable. And fourth and finally, it has to have a spendthrift provision in it. Now, here's the warning. Your typical spendthrift provision isn't going to work. Read the statute. It has very specific language, and I would not recommend you use anything but the language of the statute to create this spendthrift provision. The next requirement is a qualified affidavit. When you make a transfer to this trust, you have to have the transferor sign a document with 7 declarations in it. Basically, the transferor owns the property. The transfer will not make the transferor insolvent. Very important that the transfer is not to defraud a creditor. There are no pending court actions. There are no pending administrative proceedings, and then there's no contemplation of bankruptcy, and it's not derived, money's not derived from unlawful activities. This affidavit is required for the initial qualified dispositions to the trust. While it's not required for later dispositions or gifts to the trust, do it. Why? It protects you, the lawyer. It protects you, the planner. It means that the transfer is saying all these things under penalties for perjury, which gives you the basis for creating the trust. If you have a trust already existing and it wants to become a legacy trust, the transferor to the original trust still needs to sign that affidavit. If the transferor is married, he has to give a copy of the qualified affidavit to his spouse. If he or she are planning to get married, you have to give notice of the transfer if you're within 30 days of the wedding. You have to give notice to the other spouse more than 3 days before the transfer is to be made. That is the protection for pending marriage. Now, there is a requirement that if the assets transferred to the trust were listed on a financial statement or a balance sheet given to a bank, that you give notice to the bank, but it's not a requirement to set up the trust. And it's really just all the bank can do is ask for then a certification of the trust. And we talked about the later transfers. All right, what does that get you? Protection from creditors, including the settlor, who can be a beneficiary of any distribution from the trust. The protection is broad, it's broad-based, and it is intended to be that way. Now, there is a Federal Bankruptcy Code section some of you may be familiar with. The actual transfer is considered to be enforceable under applicable non-bankruptcy law within the meaning of that statute. Two issues that often arise. Jurisdiction. This is usually a problem when you have someone who's out of state and goes to another state and creates a domestic asset protection trust. The issue is who has jurisdiction. Alaska, the first, claimed exclusive jurisdiction. Not too long ago, they had a case and the Alaskan Supreme Court said, we went too far. That's unconstitutional. Ohio, one of the more recent adapters of a domestic asset protection trust, went to a jurisdiction to the extent that is allowable under either federal or state constitution. That's the language Indiana has used. Choice of law is an even bigger issue, especially if you have someone who's not living in the state where the DAP is created. Indiana, like most of the other DAP states, has a provision that says if your trust is, and your DAP trust is sued in another state, and the other state decides to apply a law other than Indiana, then the only thing the trustee can do is resign, creating kind of a standoff. Now, there's no reported cases on this or how it works, but it is kind of the preferred way of trying to force other states to use Indiana law. Now, here's kind of the practical point. I don't think anybody from out of Indiana is going to create an Indiana legacy trust. The main reason is Indiana taxes trust income. The states like South Dakota, Nevada, that actively, and Alaska, they actively seek this kind of business, do not tax the income of these trusts. So we will always be at that disadvantage. But it does verify and it does validate any kind of planning for Hoosiers by Hoosiers. The alter ego argument we talked about a little bit before. If you have my material, that's page 7 and 8. What we're talking about here are arguments that were made in court to tax Spendthrift Trust, and legislation now designed to kind of restrict that court invasion into Spendthrift Trust. Key among these is that even though the trust allows the trustee to be replaced by the beneficiaries, or even though the settlor may accidentally sign some checks commingling, or even though you may make requests on the trustee, that does not create an alter ego situation. And then it addresses many other factors that courts have used to attack it. The legacy trust itself has provisions about what rights the settlor, transferor can keep under the legacy trust. Their long list that's on page 9, but the key at the top, 1 and 2, the trustee, or I'm sorry, the transferor can keep a veto right over distributions. In other words, can't tell the trustee or the distribution director what to do, but can say, don't do that. And can also keep a power of appointment by a testamentary transfer, as long as it's a special power of appointment, which means can't point it to himself, his creditors, or estate, or his creditor's estate. Now, if he, the transferor, or she keeps those powers, they have not made a completed gift, which may sound silly. You may say, why are you creating this trust and you haven't made a completed gift? Well, it may be because your estate is well under the $11,580,000 exemption, and you may want to get some stepped up basis. If you make the gift, you're going to go with, of course, the donor's basis. So you do have some flexibility there. Very carefully, selection of the trustees or the directors. Now, when I say directors, I'm referring to the Uniform Trust Act. I think Jeff Dible is going to talk about that, which allows for multiple fiduciaries with separate duties to take care of the trust. But these people, by the legacy law and by Internal Revenue law, basically have to be independent, which means they can't be your spouse. They can't be your descendants or your spouses of your descendants. They should be independent. Now, the drafting side of that is you put in there the right to remove them if you don't like what they're doing. So you pretty much have the leverage to keep them in line. Creditor exceptions. As originally worded, we said that the only creditors who can get to the assets of a legacy trust are creditors listed in Section 8. During the course of negotiation with mainly organizations representing bankers, 2 other exceptions were added. So we'll talk about those last. But the first main exception is a transfer that violates the Uniform Fraudulent Transfer Act. Now, Indiana has had this act for some time, and in fact, recently updated it with language from the Uniform Voidable Transfer Act. Jeff Dible and I had the fascinating chance to sit down with legislators when this was being considered 2 or 3 years ago. Whoever wrote the Uniform Voidable Transfer Act did not like Spendthrift Trust. And so in the comments, they put in there that almost any transfer to a spendthrift trust was a violation of this act. So we got, Dible and I got Indiana to say that the comments to the uniform law cannot be used in Indiana. And we've gotten some positive publicity from that from other states who are now dealing with the exact same problem we were considering back then. So it's still called the Uniform Fraudulent Transfer Act. It's updated for the Uniform Voidable Transfer Act, but the comments don't apply, which is good because if you just stick with the letter of the law, you'll be fine. Now, under the old Uniform Fraudulent Transfer Act, it was a 4-year statute of limitations for someone to bring the act from the time of the transfer, or 1 year from the date of the recording of the transfer, or they should have known about the transfer. That still applies to the state of Indiana, no matter what. But for everybody else under the legacy trust, it's a 2 years from the date of the transfer or 6 months from the date of the recording. In other words, a greatly compressed statute of limitations. Also, the burden of proof has changed from preponderance to clear and convincing evidence that there is a fraudulent transfer. So there are changes there that are very important. Now, there's a ton of case law on fraudulent transfers, and not my intent to try and cover it. But you need to kind of become a little bit of a creditor, debtor, lawyer to do legacy trusts. The second exception as a creditor is child support. Almost every state with ADAPT accepts child support, except for Nevada and Alaska, which do not allow claims for child support. We talked about the marital property. You need to give notice to the spouse, or if you're going to get married, you need to give notice to the intended spouse. Not in the legacy trust law, but the bankruptcy law is a very important provision. 2005, the bankruptcy courts and the legislature said, hey, we're not so sure we like these self-settled trusts. And so they created a clawback for the trustee to get property back if a transfer was made to a self-settled spendthrift trust. And of course, the settlor is the one being protected if it was made with actual intent to hinder, delay, or defraud. This is, again, not in the legacy trust provision, but it is definitely something you have to keep in mind if you're making these, because if your client heads into bankruptcy, the trust is probably toast if you're within that 10 years. All right, to the two additions by the banks, they also accepted from protection from the bank. Any bank that has a financial statement or a balance sheet showing the asset, and the asset was later transferred to the legacy trust. There's a problem with that we got fixed in this year's legislature. It didn't talk about if the bank had been paid off or whether or not other creditors could get to it. So we made it clear in those changes that it only applied to the asset, and if that loan was paid off, then it did not become an exception. Let me cough for just a second. Okay. Now, the second item that also got fixed, the bank said, okay, if our lending documents prohibit transfers to these types of trusts, then you cannot transfer them. And so that's in there. And let me also say my limited experience shows that a lot of times the loan documents, security agreements will say you cannot transfer the collateral anyway. So you need to be aware of those in your due diligence and make sure you look at those. Case law, not a lot on domestic asset protection trust. You'll find quite a bit on foreign asset protection trust, because you'll find that the bankruptcy courts do not like foreign asset protection trusts. Famous case, and I can't give you book and verse or site, but there was a gentleman transferred everything to a foreign asset protection trust and sat in jail for over a year while the judge said, you're going to either bring it back or you're going to sit in jail. I'm not sure. Dible may know the result of that. But I'm going to kind of summarize the cases under domestic asset protection trust and what I think they're telling us. They're telling us these are not trusts that you can abuse creditors with. We have a couple cases where there was people who were either already being sued and well underwater, or knew they were going to be sued, and also tried to create this trust on their own and didn't follow the formalities. That didn't take long for the trustee in bankruptcy to claw it back, or the court to say, you didn't create a valid asset protection trust. So you have to be on the requirements. One guy in Tennessee created a Tennessee domestic asset protection trust, but he was a trustee. He had the power to amend and revoke the trust. He didn't do anything right. It didn't take the court long to say, no, this doesn't work. But we do have cases where it has worked. In Delaware, there's a Tresco Bank versus Susan Matthews. Delaware has an interesting court system, chancery, which deals with equitable claims, in this case, latches. The court, while trying to decide if latches applied, actually applied the shortened statute of limitations to the Fraudulent Transfer Act. And then out of Nevada, the trial court was confronted with a married couple. They had created separate trusts because Nevada's a community property state. But then along came Nevada's Asset Protection Trust. And so they each took their individual trusts and made them asset protection trusts. And they were substantial trusts. 8 years after doing the asset protection trust, they divorced. The wife said, let's even this pot up. Let's make each of our trusts $8.7 million, which is the implication is the husband had more in his trust. The trial court agreed and also awarded $900,000 in child support. The Nevada Supreme Court did not really take very long to say, hey, we actually promote these trusts. Nevada wants people to create these trusts, and you really have to take the trust and the language of the legislature at its word. And so it denied the splitting up of the trust, and it also struck down the child support because, as I said earlier, Nevada doesn't recognize child support. Liability. Do you have any liability if you create one of these things, whether you're a trustee or a lawyer? We actually, taking language from other states, tried to put in the Indiana Legacy Trust protection for trustees and drafters. And it was simple protection. All it said was, hey, there's nothing illegal about doing this, and there's no liability that results from professionals who participate. The opponents said, oh, that's proof that we were doing something evil, so we took it out. So the question now becomes, do you really have much of a liability? The answer to which is no, you do not. Again, if you're doing what the statute requires, I can't see any liability. The liability, if any, comes if there is some type of a fraudulent transfer or scheme to defraud the creditors. In that case, if you're the trustee and you know about it, you could be aiding and abetting a conspiracy. If you're a lawyer, similar results. So what are you going to do? You're going to do due diligence. You are going to want to make sure your file reflects that the qualified affidavit that we talked about earlier, everything in there is true. So you're going to want to look for the bank records to make sure there's no prohibition against transfer. You're going to want to look at the bank statements and the balance sheets to make sure you're not transferring assets that would somehow violate that. You do want to know about all of the creditors, not the utilities, but you want to know what's out there and what's to be expected. And you do want to end up with a settlor or transferor who is still very solvent, even though transfers have been made to these trusts. Since this law's passed, and of course I've been intimately involved with it, I've probably gotten over 30 phone calls to create one of these. And every single one of them, it's somebody who's trying to get rid of creditors that have been after them for many years. And I've had to say, it ain't going to work. You're not going to be able to truthfully say you are solvent under these circumstances. So it is really more of the nest egg approach. It's the professional who accumulates lots of property and money, and instead of putting it all in his wife's name as his own plan of asset protection, it's a way of taking those assets and putting them away and sheltering them as long as he still has enough to be solvent and pay the bills. Now,
I'm sorry to interrupt here, but unfortunately we need to move on to Jeff Dible at this time.
Oh, that's fine.
Okay.
Thank you.
Thank you. Where is he?
I think I'm unmuted. Okay, I'll probably use every bit of my 25 minutes, but if I don't, we'll start the Q&A a little earlier than would otherwise be the case. My paper is 59 pages plus three preliminary pages, and it really covers the legislative changes that have been made in Senate Enrolled Act 265 last year, and to some extent Senate Enrolled Act 518 last year, and then the cleanup corrections that were done in Senate Enrolled Act 50 this year. I'm going to be referring throughout to the pages in the PDF. It would be helpful if you had the PDF open on your screen in front of you. For those of you who printed out the whole damn thing, you can just take my page number references and subtract 3 from each one. That will be the pages at the bottom of the page as printed on the paper. So PDF page 4, I've got references to the Supreme Court's order in case number 20S-MS-237, which applies to wills and codicils. I also refer to the relevant executive orders issued by Governor Holcomb. The first few pages I have used to compile the best and most careful commentary and suggestions that I've seen from trust and estate lawyers all over the state, dealing with how do we help clients who have limited mobility or who are under home quarantine or are under lockdown in residential care facilities if those clients need or want to sign updated wills and codicils. We're still working currently on the Supreme Court's order in MS 237, and that was issued on March 31st, and then the Supreme Court supplemented on May 1st saying, basically, we can continue to use that order until the Supreme Court issues another order declaring an end to the public health emergency. Now, that might actually happen on a different date than when Governor Holcomb declares an end to his public health emergency. The two don't necessarily coincide. So the Supreme Court could decide they're going to keep that MS 237 order in effect for a little longer than Governor Holcomb does. And as long as that's the case, we can rely on the suspension of the direct presence requirements for the witnessing of wills and codicils. On PDF pages 5 and 6, the first table that you see there summarizes what the probate code and trust code provisions actually require for proper signing and witnessing of wills and codicils, both on paper and electronic, and for proper signing of inter vivos trust instruments in the far column on the right-hand side. For wills, codicils, POAs, and many other kinds of healthcare directives, it's long been possible and explicitly legal for a client, the testator, the principal, the declarant, etc., to direct somebody else to sign for the client if the client could not hold a pen and make a signature. Well, effective July 1, 2020, Senate Enrolled Act 50 amended the trust code to insert a similar rule for trust instruments signed on paper and also electronic trust instruments, which means that the settlor could direct somebody else to sign the settlor in the settlor's direct physical presence. Now, of course, there's no requirement that an inter vivos trust instrument has to be notarized or witnessed, which makes them a little bit easier to deal with when a client is physically isolated and they're not able to come to the office. For traditional wills signed with wet signatures on paper, the probate code requires the testator and the witnesses to sign in each other's presence, but presence is not defined in the probate code section. So there's a decent argument that for a traditional will signed on paper, even if we didn't have the Supreme Court's MS 237 order, current law would allow the presence requirement to be satisfied through the use of two-way audio-video technology so that the testator and the witnesses can interact in real time with each other and see and hear each other throughout the signing process. I think that's a decent argument. For electronically signed wills and codicils, presence is defined in Chapter 1 of the Probate Code to require actual direct physical presence of the testator and witnesses in the same space so that they interact without the use of audio-video technology. That was a deliberate policy choice that was made when the e-will statute, which is Public Law 40-2018, was drafted and enacted. So for the time being, we rely on the Supreme Court's MS 237 order as the basis for doing remote witnessing of electronic wills and codicils. At least one subcommittee of the State Bar Association's Probate Review Committee is working on a more careful, thorough, and permanent solution through legislation, which cannot be enacted before Organization Day next fall, or more likely before the 2021 session of the General Assembly starts next January. So that's in the works. In the meantime, we're dealing with and relying on the MS 237 order. Now, for the reasons I explained in the paper, I believe the Supreme Court's order allows remote witnessing of wills and codicils that are signed electronically, and also allows remote witnessing of wills and codicils that are signed on paper with ink signatures in counterparts. where the physically isolated testator signs one paper, original counterpart, and where the two witnesses sign one or two other counterparts, also on paper, that the organizer or lawyer later assembles into one combined original that contains all the signatures. I think that is completely legal. On the bottom of page 6 of the PDF, I have references to 3 appendices, Appendix 1, 2, and 3. Appendix 1 starts on page 36 of the PDF, and it is simply a self-proving affidavit and signature block combined, one set of signatures for an electronic will that would be signed with actual direct physical presence. So we're not relying on the Supreme Court order. There's no remote witnessing. On page 37 of the PDF, Appendix 2 is a signature block and self-proving affidavit for an electronic will that would be signed with remote witnessing and relying on the MS-237 order. And the text that you see in red is the extra text that the MS-237 order requires us to include either before the self-proving affidavit or within the self-proving affidavit to explain how we're relying on the Supreme Court's order. And on PDF page 42, I've got Appendix 3, which is my suggestion for a signature block and self-proving affidavit for a traditional will that would be signed with a wet ink signature on paper on separate counterparts with remote witnessing, again in reliance on the MS-237 order. It should be obvious that when people sign these things in reliance on the order and you're using remote witnessing, if there's real money at stake at the time the person dies, there could probably be litigation. And so I expect we're going to see some cases in which somebody will challenge the validity of an e-will or a paper will that's been signed with remote witnessing in reliance on this MS-237 order. One of the things that the order requires is that within 90 days after the public health emergency ends, if the person that signed is still alive, you have them re-sign or ratify a document according to Hoyle in the traditional manner without remote witnessing, and then everything is good. And I would argue, as I think Jeff Kolb has, that if the person dies before being able to re-sign or ratify, that's not going to necessarily invalidate what they signed in reliance on the Supreme Court's order, because the law doesn't punish people for doing something that's impossible. You can't come back from the dead to re-sign in the traditional manner. Starting on page 7 of the PDF and continuing to the top of page 10, I've summarized 3 methods or approaches, which I've labeled A, B, and C, for actually managing and accomplishing the actual signing and witnessing of a will with remote witnessing in reliance on the MS-237 order. If the testator is isolated at home, in quarantine, or under a lockdown in a facility, and if the testator therefore cannot interact in person with witnesses in the same room. There's another workaround you could use if you have a competent client but cannot accomplish remote witnessing. Simply have the client sign an inter vivos revocable trust, which doesn't require any witness signatures, doesn't require notarization, and then use the client's existing durable POA or simple one signature assignments to fund the trust with the client's assets. I think that ought to work. Page 11 of the PDF, a second table summarizes the signing, notarization, or witnessing requirements that apply to durable powers of attorney, healthcare appointments, and living wills. And the only common and significant estate planning documents that require notarization under our law are the transfer on death deed and the durable POA. Well, for both traditional POAs signed on paper with wet signatures and electronic POAs signed electronically, the relevant sections of the POA statute do not define the phrase, quote, presence of a notary, unquote, and don't explicitly require that the principal sign the POA in the direct physical presence of the notary. And because the POA statutes don't require signing in the direct presence of the notary, over the long term, I think that means that notarization remotely online can be used. We've got a temporary obstacle in the form of a shortage of Indiana commissioned notaries who are authorized by law to do remote online notarization. Over time, that's going to change. And eventually, we'll have out-of-state notaries with outfits like Notarize Inc. and Notary Cam who will register with the Indiana Secretary of State's office, and they'll be able to do our remote notarizations for transactions and clients who are located here in Indiana. Now, you're probably aware of the Supreme Court's order in case MS-236, which allows remote swearing and acknowledgments in litigation for affidavits, court testimony, and depositions. There's nothing explicit in that MS-236 order that says remote notarizations can be used for deeds and estate planning documents, especially when there's no swearing to facts involved in the documents themselves. there is a barely plausible argument, which I was making earlier this spring, that the MS 236 order is worded vaguely enough to allow remote notarization of TOD deeds and powers of attorney and estate planning documents, but I've never been totally convinced by the argument. And within the last week or so, I've acquired information leading me to believe that the Supreme Court probably didn't intend for that 236 order to actually be so broad as to allow you to use it for powers of attorney and deeds. So what that means is if you do remote notarization, you're taking some risk, even with that 236 order in place. On pages 12 and 13 of the PDF, I described 4 workarounds for getting a healthcare POA or a financial POA signed by an individual who is physically isolated under home quarantine or in lockdown in a facility where that individual cannot meet in person in the same space with a notary. Well, the first of the 4 workarounds is a cheat. Don't try to have the client sign a POA at all. Just have the client sign a healthcare appointment under 1636(1)(7), and that doesn't require notarization. It requires just signing it by one witness in addition to the appointor, the client. And the statute doesn't say that you have to have the witness sign in the presence of the client who's signing the appointment. So that's one workaround. The others, which you can read in the paper, actually deal with how the heck you get the POA notarized. And I won't go into detail on that. You can read it for yourself. Incidentally, to my knowledge, there is no Supreme Court order or executive order from Governor Holcomb that applies to powers of attorney or healthcare directives, except for part of Executive Order 2023, which the governor issued on April 23rd, and the key part of which is quoted verbatim, starting about on page 12 of the PDF. That only applies if somebody is signing a healthcare appointment by directing somebody else to sign. And if you're doing that, the governor's order says you could interact remotely with the person who's signing on your behalf, and they wouldn't have to be in the same space with you. Okay, I've now reached the bottom of page 13 in the PDF of my paper. Let's now switch gears to some legislation that became effective on July 1st, 2019. Quiet trusts. These are trusts where the trustee is required to keep the trust's existence and the nature of the beneficiary's interest concealed from the beneficiary for a finite time period. There's a good argument that quiet trusts were always legal in Indiana if the drafting was done correctly in reliance on Indiana Code 30-4-3-6 b. But quiet trusts were explicitly validated by amendments to that same section of the trust code made by 2019 Senate Enrolled Act 265. There were some clarifying amendments and technical corrections made this year by Senate Enrolled Act 50, and those are effective July 1st of this year. Starting on page 47 of the PDF, Appendix 4 includes all statutory text relevant to quiet trusts, and the 2019 and 2020 changes are highlighted in a different font. Starting on page 18 of the PDF, I've included 3 practice pointers. A beneficiary who's being kept in the dark, that is being kept uninformed that the trust exists or that he has an interest, pretty much has to have a designated representative or a DR under subsection D of 30-4-3-6. And a definition of designated representative or DR was added to the definition section of the trust code, which is new subdivision 7 in 30-4-1-2. The designated representative or DR is the person who can receive accountings and notices on behalf of the beneficiary who's being kept in the dark, who's being kept uninformed. The DR can also sign waivers, consents, and ratifications on behalf of that beneficiary, because the DR can virtually represent the beneficiary under our representation section in Chapter 6 of the Trust Code, 30-4-6-10.5. Even if you are designing and drafting a trust that will not be a quiet trust, I strongly recommend that you do include a provision that creates a procedure for appointing a designated representative or DR for any beneficiary who, A, is not an adult, B, is incapacitated, C, is unborn, or D, cannot be located after reasonably diligent search. Those kinds of beneficiaries are the main reason that you frequently have to go to probate court to have the court appoint a guardian ad litem to represent those people in order to give them notice and to get a proceeding properly handled. You may have nobody else who is free of a conflict of interest who could represent that person's interest virtually. This is where the ability to name a DR in a trust document really comes in handy. You can avoid having to go to court to get a GAL appointed. I have been including a DR appointment provision in every trust that I've drafted, inter vivos, testamentary, revocable, irrevocable, since July 1st of last year, and I recommend that all of you do this too. And you'll find a sample provision at the bottom of page 51 in the PDF within Appendix 4. On 19 and 20 of the PDF, I offer my reasons for why the trustee of a quiet trust cannot really keep the trust's existence concealed from beneficiary who is not seriously disabled if the trustee makes any distributions at all to or for the benefit of that beneficiary. Because if there are distributions made, there's going to be K1 income carried out, and any beneficiary who's paying attention is going to read the K1 and discover, oh, I'm a beneficiary of the trust. And then all bets are off. Okay, page 20 of the PDF. Another important tool added to the trust code effective July 1st of last year makes it easier to avoid a court proceeding for approval of a trustee's accountings in 3 situations. 1, a trust is terminating and the trustee wants to be released and discharged with respect to prior acts, even if there have been no prior accounting statements given to the beneficiaries. Or 2, a trustee is resigning and a trustee is stepping in as a successor, and the trustee who's resigning wants to be released. Or a trust is continuing to be administered, but one beneficiary has died and there are new beneficiaries coming in, and you want to be able to get releases from with respect to acts before the beneficiary is changed. In those situations, new section 30-4-5-14.5 provides the procedure. The trustee provides accounting statements for the last 3 years, plus a notice with prescribed content, and gives the qualified beneficiaries 60 days to submit objections. If there are no timely objections, or if the objections are resolved, then the trustee is released and discharged with the same finality and effect as if a court had settled and allowed the accounting statement after a court proceeding. I've already used 14.5 3 times since July 1st of last year. Also effective July 1st of 2019, new section 30-4-5-25 allows the use of NJSAs, non-judicial settlement agreements, to resolve disputes or problems in the interpretation and administration of trusts, where court approval is entirely optional. You can just skip it. An NJSA could be narrower in scope potentially than a court-approved compromise settlement under Chapter 7 of the Trust Code, and only the beneficiaries or persons who have actual interests in the problem or dispute who would actually be affected by the NJSA have to sign the agreement. And unlike a court-approved compromise settlement under Chapter 7 of the Trust Code, where you have to have the court approve it, you don't have to actually allege that there's a good faith controversy regarding the trust. But I think when you draft these things, it's always a good idea to say all the people who sign agree that the effect of the agreement on their rights and interests is just and reasonable. There are 3 potentially important constraints on the ability of trustees' beneficiaries to use NJSAs to resolve disputes. The first is that the NJSA cannot violate any material purpose of the trust. Second, the modifications, if there are any, made by the NJSA cannot be changes that the probate court couldn't order in a modification, reformation, or equitable deviation proceeding under Chapter 3 of the Trust Code. And then last, the NJSA cannot modify or terminate the trust in an impermissible manner, quote unquote. Nobody knows what that's supposed to mean. On page 22, I offer some practice pointers. Next to last topic, effective July 1st, 2019, the Indiana General Assembly enacted the UDTA, Uniform Directed Trust Act. It has important implications for drafting and for trust administration. You can't draft a trust now like you could before July 1st of last year that basically says anytime somebody directs the trustee to do something, the trustee must obey, and the trustee is always absolved from any liability to the beneficiaries as a result of obeying or complying with the direction. You can't do that anymore. You've now got a new set of rules in place. It is going to make drafting easier, make design easier, but I would encourage you to basically read the entire chapter, new Chapter 9 of the Trust Code, and be familiar with it before you draft any trust that includes a trust protector, trust director position. I have some drafting suggestions that I'll skip here for the interest of saving time. Okay, last few minutes. There's legislation that I cover starting on page 28, the bottom half, that didn't pass this year. This was House Bill 1317, which was an overhaul of the advance directive statutes. It was passed by the House 94-0 on January 30th. Then it basically stalled in the Senate. Didn't even get a committee vote. It just died for reasons that didn't have much to do with the merits and the contents of the bill. We worked for 2 years on this bill. And this is what it would have done. And this is what we think it will do if we bring it back and introduce it again and get it passed next year. We've taken all the key provisions from the Indiana Healthcare Consent Act, 1636-1, and the healthcare powers provisions in our POA statute. We've reorganized and consolidated them and clarified them into one new chapter entitled 1636-7, so that the rules and the default settings are easier to find and easier for healthcare providers and their lawyers to understand. Secondly, we have preserved all the drafting flexibility that Hoosiers and their lawyers currently have in designing and structuring healthcare POAs. So you could draft a document that would function like a healthcare POA, same flexibility, same rules, you just call it something else. You call it an advance directive. After a 2.5-year transition period, we would replace the healthcare POA under Title 30 and the healthcare appointment under 1636-1 with this new single type of advance directive that could be signed either on paper or electronically, and either signed with 2 witnesses or signed with notarization. And finally, on advanced care planning, end of life, and palliative care issues, we would allow Hoosiers near total flexibility to include statements of wishes, instructions, and treatment preferences in this new style advance directive without any of the constraints currently imposed by our living will statute, which is almost useless from my perspective. House Bill 1317 would have authorized and required the state health department to promulgate an unofficial sample form of the new advance directive, but unlike the current living will, it would not be a prescribed statutory form. And back in 2019, as a proof of concept that you could actually come up with a form pretty easily, I produced some sample forms, and then this year, in early January, I updated those sample forms and came up with 3 forms. There was a shorter form, a medium-sized form, and a longer form. And in Appendix 5 on page 50, you'll see the longer sample form, and on page 56, Appendix 6 is the shortest sample form. If House Bill 1317 had been enacted, it would have been easier for individuals to execute the new style advance directive when physically isolated from witnesses and notaries and so forth. But the bill didn't deal explicitly with what we are now experiencing daily with COVID-19, and so it didn't talk about remote notarization, remote witnessing, or signing in counterparts. So in preparation for the 2021 session, I've taken a key new section from House Bill 1317 and then modified the text. You'll find that on pages 32 to 35 of the paper to show the approach that we could take to explicitly allow remote witnessing, remote notarization, and signing in counterparts for this new type of advance directive. If you've got strong opinions about this, I'll be happy to take your email. I can send you a comparison table that will show you that 75% of this bill is really corresponding to existing law. If you want to see this bill killed, tell your legislator. If you want to see it passed, tell your legislator. And as always, I'm welcoming your criticisms and questions and comments. Thanks very much.
Oh, Carrie, before you jump in, I want to go all the way back to the very beginning. We had a question when Jeff Hawkins was discussing his topic. Jeff, there was a question around who takes authority if there is no filing in the first 5 months. Does the AG's office do that, or what's the necessary step?
I just posted a response to that to everyone so they could have it in print because it's kind of lengthy. The bottom line is, and this is a disconnect that lots of people have. So it's a great question. Title passes under 291723 automatically, immediately, and indefeasibly at the moment of the decedent's death. Period. There's no need for human involvement in it, except that the person representative has the power to open, if there's an estate opened that satisfies the requirements of 291715.1b and subsequent subsections, then the person representative can sell the real estate to generate cash to basically pay the bills of the estate. If the person representative doesn't satisfy, if the estate isn't opened in a timely fashion to satisfy the limits in 15.1, so the 2917 15.1, then there is no disruption of the passage of title, the automatic passage of title to distributees, and so the distributees simply own the real estate as a matter of law. Nothing required to get that job done. So there's no authority needed because the statute is self-executing basically.
But if I could jump in, title passes at death. So when you're talking about the 5-month period where there's no estate administration, the authority is with the owners. If it's intestacy, it's with the heirs. If it's by will and the will is probated, it is the beneficiaries under the will. So it's just like any other ownership, or when a deed transfers ownership from one person to another, the date of death is a transfer.
You can basically think of the person representative as a defensive back on a football team trying to intercept the pass. The decedent dies, and upon death, the pass is in the air. The beneficiaries get it unless a person representative is appointed by the court in a timely fashion so that they can intercept the pass and sell it and distribute it to the beneficiaries. Otherwise, the pass is complete and the beneficiaries run for the touchdown.
Nice.
That's a great way of putting it.
There's a weird issue. I'm sorry. There's a weird issue, and I addressed it in my posted comment. With an intestate decedent, you have this weird limbo. It passes to the distributees upon death. However, we don't know who the distributees are until the will is probated, which may take weeks or months after the decedent's death. So you have this weird statutory concept where it passes to those people, but they're not identified until the will is admitted to probate, and that has to be done under the time limits under 2917 15.1 as well.
Which really there are no time limits for decedents dying after, I forget, 1998.
Well, there's some procedural things if there's an estate opened and a final allowance of.
If you have a piece of property still in the decedent's name, I don't think there's any time limit on probating the will.
Okay.
I believe Pete's question was the only one I saw in the Zoom group chat. Does anyone else have any questions that they would like to either be unmuted and ask live or enter in the Zoom group chat?
I have a question if I can.
Go ahead, Randy.
Okay, this is with what Jeff Kolb just said. I mean, the other two Jeffs agree with that the probate, I mean, you're saying that you can, presumably, if a will hasn't been probated, you assume that the real estate goes to his intestate heirs or his or her intestate heirs, but that's, if they haven't sold the property, 7 years later, a will is probated, that title then goes to the heirs under the will.
This is Jeff Dible. I agree with that. If you look at the last two lettered subsections in section 15.1, I think it's now G and H, they basically say, create exceptions to the principle that you're supposed to probate a will within 3 months, 3 years after the decedent's death. If you don't do that, you're out of luck. Well, there are exceptions for if you discover the property is still in the decedent's name, you can probate the will in order to basically update or clear title. And so if you've got somebody who died 7 years ago and the county recorder and auditor still shows this dead person as the owner of the real estate 7 years later, you're not prevented from probating the will and then recording that. It refers to the will and says, here's where the property passed to. It passed to these people under this probated will. You can always do that. I've never had a problem with being able to probate a will after 3 years if what you're doing is trying to deal with real property that's still titled in the dead person's name.
The decedent has to die after June 30th, 2011. and there has to be no estate proceedings. So if they did an intestate estate and distributed, well, then you cannot probate the will.
That's right.
Yeah, and that was the one I was referring to. That's in subsection A, 2917-15.1. That you can't probate the will after a final decree of distribution has been entered or after a closing statement in a unsupervised estate has been submitted.
So then if you are in intestate heirs and you don't know of any will that exists, if you're siblings, for example, you should do something with the property. You should transfer the title to a trust to do, or some kind of transfer in order to prevent that from happening.
Yes.
Yeah. And ultimately, you need to do that anyway because you need to be notified of property tax issues and other matters. If you don't do something, you're not going to be in the loop for things that affect the property.
Or open an estate administration intestacy.
Mm-hmm.
Does anyone else have any other questions? Okay, on that note, it looks like we're gonna end up finishing on time. I appreciate the three Jeffs for your time today. I also appreciate you condensing a lot of material into 25 minutes each. For those of you that are members, I'd love to hear your feedback, and we'd entertain having the three Jeffs back in person, hopefully in the future, or maybe using this format again, if it worked well for everyone. So thank you, Jeff, and Jeff.
Thank you.
Get us moon suits, we'll come in person.
I think, Carrie, for the remainder, this actually wrapped up our series for our fiscal year for the Estate Planning Council. We've always taken the summer months off because we know that that time is very valuable for vacation timing and different things, although this year may look a little different for everybody. I think that our next event is scheduled for, Carrie, I'm kind of putting both of us on the spot here. Do we have something in place?
The next one is scheduled for October. So it is almost about a 6-month stretch. But we would do the next event in October, which is the 3-hour continuing education credit opportunity. We're hoping at this time to be able to offer that in person. And if not, we may do a hybrid event where we have folks have the ability to call in if they want to do so remotely, including the speaker who is in California. I'm not sure she'll be willing to come at that time, but we'll see what happens. And then traditionally our last event is in December, and we're hoping to have that at Essen House eating pie like we always do. So we'll see. But yes, as for the summer months, there are no other events scheduled.
Well, thank you again, everybody, for joining us. We appreciate your flexibility on doing this by Zoom. We recognize that this is a different format, but one that we're all getting very comfortable with. So appreciate everybody's attendance today. And again, I will echo the three Jeffs. Thank you. It looks like Jeff Hawkins is the only one left, and he put a note in there on reading his appendices to his report. You guys did a great job of preparing all the material for us today, and we really appreciate what you've done and shared for our group today. Thank you again. Carrie, do you want to end us out?
A final thanks to Deb Beaverson for recommending these speakers to us today. So thank you all, and I hope you have a nice afternoon.
Take care, everybody.